I'll begin with you now. As a counsel to Senator Natasha Akpoti-Uduaghan and a witness to the investigative hearing that turned into a shouting match, how do you think the chaos has impacted the merit of the petition being considered at the moment?
Well, I wouldn't know, because I would say that when we went there for the ethics committee hearing, went in good faith to be able to address the issues that were raised in the petitioner's claim. But we had some preconditions upon which we would be able to make our testimonies on that day. But unfortunately, it looks like the committee had a pre-arranged plan, for us. It is a trite rule of law that you can't be the judge in your own matter. So one of the things that we had raised was the issue of the integrity of the committee. And I think that's been the problem right from the onset. Right to fair hearing, enabling people to be able to speak, truth to power. And that was exactly what we did. So if that would affect, anything, it's better to err on the side of the truth, than to err on the other side. So it depends on what they want to do. And from my understanding on that day, they already had a copy of the court processes where Senator Natasha has been taken to court by Mrs. Akpabio, which was what they resorted to. So they came back on that day to say that since the matter was already in court, so it would be prejudicial for them to go ahead on the matter. So for us, we'd rather take that part of the issue. So it wasn't like, for me, I think the case was closed. So it wasn't like an adjournment or that we're expecting that would be called back, by the Committee on Ethics. I think they had realized that they were not supposed to even take the matter, in the first instance. So that was what happened on that day. Well, it's right. This the issue of Senator Natasha is highly controversial, but anyway, the law must take its course. So, and that's why every country is built on checks and balances. So there's separation of power. So the legislators can make laws and they can make their own rules, but their rule can never be above or ahead of the Constitution. So the judiciary also has a role. So when there's controversy, in between legislature and the executive, or legislatures and itself, the judiciary should also be able, to determine the best way to go. So I think that, because also in and around the National Assembly, there are questions of integrity, how the National Assembly is handling the matter. So it's better if we then go before the court, to respond to the issue. We understand the politics of everything, but as a lawyer, I still have full confidence, in the judicial process. So that might be the best way to go. So we just do hope that it will be done as quickly as possible. So that Senator Natasha can do my work.
Yes, to them, the perception is that you came into the hearing with your minds made up that nothing was going to happen, and like you said, you can't be a judge in your own case. But Senator Natasha actually petitioned the committee, the Senate, and it was referred to this committee. So would you say she shouldn't have even petitioned the committee? She should have gone straight to the court because she brought the case before the committee. So the standing committee will have to sit because she brought the case before them.
We have a situation in the National Assembly. And for me, I'm first and foremost a human rights attorney, committed to ensuring that we have value-based leadership and a country that is good for us. So I have a different perception of this whole thing, and I think it's important for us to take a look at what I feel. We have a National Assembly that its rule, it's also haunting itself. You can see that there are a lot of issues happening within the National Assembly. after Senator Natasha's matter, there's been about 2 or 3 people also complaining, and then it became like a little bit rowdy, within the National Assembly, that the person is not being heard and all of that. When we have situations like this, every country has a moment where you need to have your own reflections about your rules, about whether your rules is good enough, whether you need to do some reassessment of your National Assembly rule. Now, we have the Privileges and Ethics Committee that's supposed to investigate and also address issues of misconduct. Now, but we also are, and the way it is framed there is that if you are a senator, you are not expected to bring a petition before, the Senate, especially when the matter directly affects you. And I must say that while they were drafting that, maybe they were looking at matters that has to do with constituency, and other things, or maybe national issue. They were not looking at matters that could be personal, between, the members of National Assembly. If you look at the rules of National Assembly, there's no process for mediation when there are tensions between members and all of that. So the process is also not very clear on what you would do when you have situations of sexual harassment. I assume that the drafter never thought that in a space like National Assembly, which is the highest lawmaking institution of the country, that maybe there will be such allegation. So it is, you can see that the law did not take into consideration that, because if it did, you will not expect that when someone is alleging sexual harassment, someone else should bring the petition on behalf of that person that's alleging. Sexual harassment is personal. You are the one making the claim. You are the one saying you are alleging someone else. You are the victim. So you want to allege someone else. So because if that law has taken into consideration that, they will not say that Senator Natasha does not have the locus, to bring the application by herself. So the beginning of the crisis was the person who is alleging didn't have the power or the authority, to bring the claim before the National Assembly. She had to get someone else within the constituency to come and, submit that application. So the person we appeared for was a constituent member who had said, "You have stopped my senator from doing our work." And there's an allegation that she's pushing. I have refused to be able to bring this application before you. I am bringing that application on behalf of my senator. Now, he then put in the affidavit to say, one of the ways to resolve this matter is to bring the senator to come and testify before your committee. Now, this is also after the National Assembly has barred Senator Natasha from coming into the National Assembly. So there is a lot of complication. So she can't come to testify. There is an allegation. Senator Abiola has a lawyer, sitting, representing him at the panel. So if you look at the optics does not show fairness. So we had to raise that, as lawyers. I'm over 30 years at the bar. We have to raise, these are basic principles. So we have to raise that at the inception of the discussion. There was a senior advocate of Nigeria sitting there, Senator Ibomire. So we put that on the table to say, let's clarify this before we move forward. So we didn't have, and when they asked us to take the oath, to be able to go ahead, and we realized that they were going to frustrate us if we don't take the oath.
I'd just like to ask you a quick question, because we need to go on a quick commercial break. With all that has played out, do you think that in this case, the Senate should look at reviewing its rules? I just need you to answer me that quick question in 10 seconds. Yes, they should. They should. There are contradictions. There are lacunas in their rules. So it's important for them to take a step back and take this in good faith, that there's something wrong with the rules.